I see. Okay, good.
Yeah, the one thing that's different about the restrooms is they have, with the ones that have time locks on them, the doors are closed so that they close when the time is. Otherwise, if they're propped open, then the lock doesn't really work. But
Right.
we have to actually turn the handle, which was kind of an issue with COVID. We didn't want a lot of people touching the handles. But
Yeah. Are those timer ones at Campbell, or are the bathrooms have timers on them?
I believe all the bathrooms now have the electronic timers on them. That was the change
okay.
we did, I think late last year.
yeah, that was kind of a prolonged effort with the doors and the hardware and all that. But,
Yeah.
I think it's all done now.
Okay, I don't see Council President Morton yet, but it is that time. So Matt, you want to go ahead and?
Yeah, we are live on YouTube and recording, so we're good to go.
Okay, call this public hearing to order Wednesday, March 17th. The time is 6:30 p.m. The topic is annexation of 35526 Firway Lane. And I'll turn it over to our associate planner, Jenny Dimcho.
Great, thank you, Mr. Mayor. This is a quasi-judicial land use hearing. The subject of the hearing is a request for an annexation. The subject property is identified on the county assessor's map as lot 2200 on map 4 North, 1 West, 8AC. The applicant is Mark and Elizabeth Sell. The owner is the same. Because quasi-judicial proceedings require the observance of certain procedural formalities, we will take a few moments to cover some preliminary matters and required statements. Does any member of the council wish to declare an ex parte contact, conflict of interest, or bias in this matter? Hearing none. Does anyone from the audience object to the ability of a counselor to make a fair decision in this matter? Looks like we have no audience, so I'm going to assume no. Generally, the order of proceedings will be as follows. Required statements, staff report, applicant's presentation, those in favor of the application, neutral, those opposed, rebuttal, final questions, close of the record, deliberations, and decision. The following statements are required to be made at the commencement of the hearing pursuant to City Code and ORS 197-763-5. The following is a list of applicable substantive criteria for this decision. St. Helens Municipal Code 1728-030, 1708-040-1A, 1708-060, and 171120-302. All testimony, arguments, and evidence must be directed towards the applicable substantive criteria as described, or other criteria in the plan, such as the comp plan, land use regulation, such as that found in the development code, which the person believes applies to this decision. Failure to raise an issue, including constitutional or other issues relating to the proposed conditions of approval in this hearing, in person or in writing, or failure to raise an issue accompanied by statements or evidence sufficient to afford the approving authority an opportunity to respond to the issue, precludes an appeal to LUBA, the Land Use Board of Appeals, on that issue, and precludes an action for damages in circuit court. All right, so that's that. So we've got two pretty simple annexations tonight, and I say they're simple because there aren't a lot of decisions to be made other than approval or not. So let me share my screen. So first, a little bit of orientation for where this annexation is. So here's Highway 30. Here is the former Mark's Custom Exteriors building, the roofing building, and then Burrito House. Our annexation is right here. So let's look at our zoning map. So here's that property for annexation tonight. So in this case, the property owner filed a consent to annex because they want to be in city limits. It's pretty rare that someone desires to be in the city for no reason. But in this case, the property owner discussed property value and having an interest in increasing the value of their land by having city zoning. So they're not trying to connect to water or sewer, which is a typical reason we see annexations. So that's kind of unique in this circumstance. The property is developed with a single home. It's about 0.5 acres and it's accessed off of Firway Lane, but it also abuts undeveloped Kavanaugh Avenue, just west of the site. It's currently connected to McNulty Water, PUD, and it's not connected to city sewer, although it is available in Firway and Kavanaugh Avenue if they ever desire to connect to city sewer. So abutting zoning, as with all annexations, we look at zoning and determine what to zone it upon annexation. It's surrounded basically on 2 sides, 3 sides with highway commercial city zoning. That's all those pink rectangles. And then on the other sides, it's county zoning of commercial general or C3. So it's basically commercial on all sides. So with annexations, we always look at utilities. Like I said, it's connected to McNulty Water currently. If they did want to connect to city water, we have capacity, and the same with sewer. So there's no anticipated issues with having sufficient capacity to serve the property should it be annexed. We did talk to the owner about how homes are not allowed outright or at all in highway commercial, and so they would be subject to our non-conforming use rules should they be annexed, and they still desired to annex. He basically said the value of my property is in the land, not on the actual home. So we made sure that they were comfortable with the non-conforming use rules. So again, always with annexations, we look at our comprehensive plan zoning as well. And the comp plan designation is currently unincorporated highway commercial. And the only zoning option upon annexation is highway commercial incorporated. So that's why it's a simple one. We don't have to discuss the merits of what zoning to zone it. It's pretty cut and dry. So Planning Commission obviously recommended approval, staff recommends approval, and that we set the comprehensive plan zoning as highway commercial incorporated and that it be zoned highway commercial. This annexation won't be subject to voter approval because it meets all the criteria. It's within our UGB, it's adjacent to property and city limits. So it's not subject to a vote. Any questions?
I have a comment. I sat on a agreement committee between McNulty Water and the city of St. Helens, and it was agreed upon that anyone who was going to annex into the city would realize city water and sewer.
I'm not super familiar with the McNulty PUD agreement. I do know there's certain areas that are allowed to be on McNulty Water. I'm not sure how it relates to annexation.
Once someone annexes in, then they are required to go with the city services, which is water and sewer.
Okay, I'm not familiar with the McNulty PUD agreement, so I can look into that if you're interested.
All right, we need to look into it.
Sure.
If I could address that.
Yeah, sure.
So my recollection with that is that there is an exception for that. That is the case with things of urban density, commercial buildings, lots over a certain number of units per acre type of thing. But for an existing single family lot, I'd have to look at that again, but I'm pretty sure that it would, pretty confident that it's okay. Just
that it would be exempt from requirement for hookup.
Yeah, but
I'm pretty confident, John, that it isn't okay.
Okay, well, I can look it up.
Counselor Morton, can you speak to your concern a little bit? I'm not familiar.
There was issues of who years ago of who is going to service what in certain areas. So McNulty Water kind of had very big concerns about who is going to service who. And so the mayor and myself committed with Mr. Higgins at that time, who headed up the discussion at the courthouse, because Columbia County has to put those agreements on file for the state. Betsy Johnson got involved. It was a big deal. And so we had that agreement that we would not, even though there could be a residence in the city limits that was using McNulty water, but once they would have to ask to come in, or if they were outside the city limits, they would have to ask to come into the city to make certain that they get city water. So it was, they were concerned, McNulty was concerned that St. Helens was just going to continue to annex and annex and annex, and then put McNulty water out of business in a sense. So it was a boundary kind of thing. But this was a huge issue, and so that's why I bring it up. I sat on a committee that hammered this out for weeks, and I would say probably at least 5 or 6 meetings at the courthouse. And that was fairly recently. I would say 5, 6 years ago.
Yeah, that was former Mayor Peterson he was with, not me.
Yeah, thank you for saying. I just want to bring that up to make certain that we're doing the right thing. So if John, if you folks could research that before you got my vote. I'm all for those kinds of things. I'm all for development. I'm all for supporting the planning commission, but I'm also thinking that we don't want to go off base.
Yeah, I'm going to follow Councillor Morton's lead on that.
Conditional approval of sorts. So.
Yeah, I mean, we can condition it. This still has to go for a full ordinance, first and second reading as well. So this would just move the ordinance process forward. I also am going to look up where the nearest water is, because if it's over a certain distance away.
You know, I believe that was discussed as well, as I recollect. But we hammered it out in detail. The county has the agreement, and that agreement was forwarded on to the state because of water issue rights throughout the state.
Yeah, it looks like it goes back to 2013. This is the signature date.
Yeah, the nearest water line is over 1,000 feet away. So even if we were to require it, that would be an unreasonable request for them to extend the sewer or the water line. So that's probably why it wasn't discussed.
Okay.
So if they had a problem with their septic tank in the future, would they have to hook up to the sewer?
Yes, definitely. Yeah, because sewer is readily available.
Yeah, because there's a bunch of properties out in that area that have multi water and are hooked to city sewer.
Yeah. So can you see this, JS? This, the pink or the yellow square is the property in question, and this is the nearest water line.
Yep.
So
And then the whole issue came up, Mayor, of okay, when that's an issue, how is their sewer bill regulated? Because the sewer bills are regulated on how much water you use.
Yep. And we have an agreement with them, with McNulty Water to.
We have that. We hammered that agreement out, I do believe.
Yeah, I know we have that. Okay, Jenny, do you want to ask in favor of and all that stuff? I know we don't have a big, but you still have to go to the protocol.
yeah, is there any? Let me see. Is there anyone who would like to speak in favor of this application? Let's see, we do have somebody in the audience.
I think we have 2 people. Probably Patrick's wife, maybe. Autumn Oliver.
You can raise your hand or use the chat function. Would anyone like to speak in opposition to this proposal? Yeah, I'm not seeing anybody, Mr. Mayor.
Okay. All right, well, we'll go ahead and close this one and then we'll go into our next one because it's already that time. So this public hearing is closed.